So firstly, in the LSB's response to her email regarding the, scheduling, they only referred to the contempt application, and that's it. And the constitutional notices. They didn't refer to preliminary issues. I don't know whether they're saying it's implicitly. So they referred to the constitutional notices, and I took that to mean that that's exactly what they said. The Attorney General should be given an opportunity to address. But in the interlocutory application, I've also said that the court should determine the all the issues that are raised in the constitutional notice as preliminary issues.
Yeah, okay.
And that they should allow us to issue a subpoena. Now, in their response, they didn't address the preliminary issues point, and they didn't address the subpoena point. And they said 18th of July is when it should be listed. Now, the problem is that that's 10 days before the hearing.
Yep.
So there'll be no time to issue to authorize the issue of the subpoena, and for them to take objection, and for the matter to be heard. That's one thing. The second issue is that the preliminary questions that we're asking to be resolved, we need the subpoenaed material for that.
Yeah, no, I understand.
So she's already rejected the subpoena, basically, because we can't.
Okay.
I mean, she's so fucked. I think she didn't bother giving the reasons because she couldn't possibly provide reasons.
Yeah, no, I hear what you're saying.
And I've gone through my notes from the hearing, and it's ridiculous what she said. So there's no indication that their counsel could not address the issues. In fact, she addressed them. She never said I can't address them.
Yes.
Address them spot on, to whatever their talking points are. So she said, contempt application, this is bullshit. Secondly, there can't be a contempt application against Heath. Now Heath is saying that the contempt application should be listed. I mean, it's not a thing that they need to research. It's just a very simple thing. The subpoena thing. Now, this is really very strange. They didn't say that the subpoena is a fishing expedition. They didn't say that this material that is being subpoenaed is irrelevant.
Right.
What they said is that on the day, the court can go behind the judgment debt. And we're saying, okay, let the court go behind the judgment debt, but you need the subpoenaed material for that. Like, the court can't get the fucking evidence on the day.
Correct.
So she agreed with us that the court can go behind the judgment debt. She said, let's do it at the trial. But then, on what basis is the subpoena not being issued? The only other thing she said is that this matter has been determined by J.R. Ellis. And, and by the way, she said that the point that they were raising about what's his name, Silver quitting is bullshit because he's still involved. He's just at a different trial right now. So even if he wasn't permanently quitting, they deliberately got someone else to spread the fucking liability and to play dumb, because what they should have done was written to the chambers and said, the counsel is not available on this date. Can you please blah, blah, blah? Because there's no point in bringing a blank person. She doesn't actually help the court.
No, I agree. And I mean, they've done that, right from the beginning. No, not just the LSB, everyone. How many counsel have been in our matters, you reckon?
I think a quarter of Victorian bar would be.
Be a fair
familiar with
number.
my. I know, like with the LSB I was counting, it's over a dozen.
Yeah. And then with all the BGSO ones and police matters and
There's no one at the VGSO who doesn't know me intimately. Like
be true.
now the other point is that so she said that I was thinking about this, right? So in her email she says, anything you've not filed in evidence you can serve via email to me. Um, Firstly, that means that she's actually going to go through the evidence, and that whatever has been filed, she has gone through it, because she's only asking for what has not been filed. Okay. Now,
Yep.
then on the day when I said the other side, if she had gone through the transcript, the moment I started going there, she stopped me. She says, "I'm not gonna let you make accusations against the other person." And I was like, "I'm making a complaint. She's breached the barrister conduct rules." She says, "Completely unhelpful, and I'm not gonna let you do that." Basically, you know, this. I said I have a right to make a complaint. She says, "Not at large. This is not a royal commission." She could not have said that about that one fucking issue if she wasn't aware of the material that we've lodged. She
So,
she said,
what do we do?
"Oh, she's gonna go. There's no doubt that she's gonna have to go now." So once we publish the material about Gorton and then her, there's no way she doesn't go. Like Peter, what she did with the subpoena, disgusting. Basically, what she told me during the hearing is that I don't read emails.
Yes.
She says, "I don't read emails. This is how hearings are conducted. If you want to send me something, you file it. You file submissions, you file evidence, but I don't read emails."
So
After
she meant, I don't read your emails.
exactly, and here's the thing: she invited the material via email, and she didn't mention that in her reasons. It's so fucking dishonest. So she didn't read the emails, she says, and the only way you raise matter, she says, if you want to raise any matter with me, you raise it by filing it. They raised the matter with her, and she adopted it straight away. And the other issue is that I went through the notes. I was very fucking thorough. I raised the matter of subpoena very clearly. I said we can make the application orally.
Yes.
The rules allow us to do that. Why are you not issuing the subpoena? We have a right to get the material. And so the judgment that you have to make is an evaluative judgment. So she says, no, this is a case management matter. I said, she's asking you to make substantive fucking orders here. She's saying, don't issue the subpoena. That's a evaluative judgment. And, then she just ran away. So, I mean, anyone will understand that she was fucked. Like, it is clear that she's not read our material, and she's read their material. It's clear that she hasn't considered any of the stuff. There is no way that she can stay in the matter. The other thing we'll do is we'll make a complaint to the Judicial Commission and to the Chief Justice, and we'll publish this all over. We will raise this in the constitutional notice. And by the way, Peter, we will file the appeal before the hearing.
Yes.
And then everything's fucked. But the most important thing is we publish everything and we go after them. And I have so many people who will. I mean, so once I start publishing about what I'm doing to the judges, I mean, there's like a group of people that will definitely go crazy about, circulating it and so on and so forth. Because they're already circulating it on my behalf, the Lawyers Weekly stuff. And I mean, one of them was asking for my help in dealing with, a magistrate. So it's disgusting what Downs has done, and there is no way she can continue to hear the matter. I mean, I'm basically going to say that the test that I've developed, the alternative to the reasonable observer, I'm going to publish the article over the weekend, explaining what the test is. And this is the essence of the test, that because the test is sort of pejorative in a sense, the symbolic representation is that when judges don't pro, proactively do the right thing, then ultimately it will, that is the test that people will resort to ultimately. Do you get what I'm saying?
Yeah, no, I know what you're saying about the test for the judges.
Yeah, like so if someone can in good faith um, make an allegation of serious corruption against the judge, and the allegation is of the kind that scandalizes the affairs of the court, then the judge must quit. There is no basis that the reasonable observer will find it comfortable to have that person continue to hear the matter. And I would say that on the basis of that, you can easily say that she committed fraud. She lied, and she knowingly lied. And the worst part is this: I told her that she has an obligation to let the Attorney General intervene.
Yes,
It fell on fucking deaf ears.
yes,
And then they wrote to her, and they said that she has an obligation, and she immediately fucking issues the orders. Do you know what I'm saying? Like, it's just so fucking stupid. And by the way, they were themselves, I mean, okay, their position is going to be that they didn't see the constitutional notice, because I read the notes. She only said she hadn't seen the constitutional notice, and I think she said that because she couldn't say anything against the constitutional notice. So, but still, there's no reason why Downs shouldn't have done the thing. And by the way, during the hearing, their barrister basically accepted. She says, yes, it's true that the other proceeding was only started to stop them from using evidence here.
really.
She said that. Why? I'm surprised you don't remember. I said the only reason why that proceeding was started
Yeah,
was to stop us from adducing evidence here, and that's contempt of court. And she said, yes, it's true that that is what was done, but then she said something completely stupid. She says, we don't even know if it's relevant. Well, if it's not relevant, then it can't be put in anyway. So, you know. But, I mean, you can't start a separate proceeding to stop people from, to go to a different judge who doesn't know anything about the matter. I mean, it's against the rules, but it's against common sense too.
yes,
And, like, even Mar, okay, if that was the sole purpose or the predominant purpose, then it was an abuser process by what Mar ruled. Because Mar, basically, in her reasons, she says they wanted very fucking wide ranging orders. And I didn't think
yes.
it was appropriate to make those orders. So I made very fucking narrow orders. And she didn't stop us from filing the material there. So, I mean, it was an abuser process on its face. So I think we do that. And the other thing we do is, so we have to raise money, but we have a little bit of time. And we get like 10 people to come as witnesses. So I was
Yeah,
counting. We have 6 right now, like the 3 of us.
yeah,
And we have Thomas, Anstey, LSB will just seek production, so that's 5. I'll get Serene Tafaha, that's 6. And
yeah,
there's a couple of other really strong people who are suing the LSB in the Supreme Court. We'll get them. We can get Tricario even, and uh, in between, I will get more people. Like I have been completely, I've cut myself off from everything while I was doing
Yeah.
the Gorton stuff. But that's what we do. We get 10 people in. Like we have to file the subpoena by what, the 11th of July, and we'll raise the money by then easily. If I've organized a lot of people over the weekend to help me release the stuff, and so uh, basically we will say that people should sponsor our case so we can create a template for them. And
Yeah. Okay.
I think when they see what I did to Gorton with the all this while Gorton was by the way, there is no way the court will not stay the orders too once we apply to them. I mean, if the Supreme Court doesn't, the Court of Appeal will. And what she's doing gives us another ground for that, for the stay. That, in the federal court also, people are prejudiced against us.
Yes.
So it's this is not really a thing, and we will raise that in the constitutional notice as well in the other proceeding. By the way, I'll raise a new constitutional notice in this proceeding as well. I mean, they're completely free, and you can. So I'll raise the issue of whether um, she can dismiss the subpoena without giving any reasons, and a bunch of other things. Um, what I'll do is I'll do the affidavit, and then I'll call her whatever I do, and then I'll raise a constitutional notice about whether she should be allowed to stay. Uh, after all the stuff that she's done and what I've said to her without charging me with contempt. I mean, it's yeah. I'm not worried about this. This is very good stuff because what is happening here is they are guaranteeing that we get the subpoenaed material.
Because of
Between
the way she's treating us.
no, so they're not saying no. That's the most important part. They have accepted that they have no proper basis to reject it, and
Yes.
they're basically acting like they just overlooked it in a bankruptcy fucking proceeding, which is called a quasi-criminal proceeding.
Yeah.
And then she cites that fucking authority to misrepresent things. That's to signal to the people. Do you understand?
Yes, I know what you mean.
The people go to that authority and then read what she said, and it's like these people are the fucking. So we do all of that, and I'm sure the court will not like what is said when it's published, and I'm sure the attorneys general will not like, and then ultimately the redeeming thing is the appeal. So once the appeal is filed, no one can stop us from filing the Delara appeal, and the I mean, I'm sure we'll raise lots of money, but also after this, I'm gonna be free. Like I don't have the kind of work that I did, and I can start making money myself as well. So um,
Okay, so with the appeal, when's the I mean, presumably we want to have the
I can file the
obviously
appeal
the
next week, definitely.
So I'm just thinking out loud. So the recusal, right? Um, we want to have that before you do the appeal.
Um, it doesn't matter because those are completely independent. Or the recusal against her is simply based on the fact that she's not. The whole test of the reasonable observer is that she might not bring an open mind. I mean, she's already not bringing an open mind.
Yes.
Like she's basically not reading our material, reading their material,
Yeah.
and not addressing any of the issues, and basically saying, don't you dare fucking make accusations against them, while they're saying that we're broke and we, sue people without paying them. I mean, it's ridiculous what she's the the whole point of the the barrister conduct rules is that they're protective of the court's process and therefore our benefit. I mean, there are special rules that barristers must follow when they are against unrepresented litigants.
Yep.
So she's going against the law in saying that, why are you raising a complaint when they break the rules? What's the whole point of the fucking rules then? I mean, this is how corruption works, that you selectively apply the law. You know, you keep very fucking strict laws, but you don't apply them equally. So some people can do whatever and the others get fucking. And it's exactly that. There is no doubt that if she wasn't paying attention to the fact that they're the legal services regulator.
Yeah. Look, as I've said to you, the judges are, protective because they've all been there, done that, being barristers. So, hence they are protective. I'm not saying that's right. I'm just saying that's the case.
No, but I mean, what about protective of the administration of justice?
Well, I'm saying they've all been there, done that as barristers.
Okay,
So that's why.
I don't think that anyone would have come across a case where the judge was called a scoundrel because he had private.
No, yeah, no. I'm
I,
talking about that.
I know,
I'm talking
I
about,
know what you're saying, but what I'm saying is that they should. This is the kind of case that should, like shake people out of their comfort zone. Because the way, I mean, they're quiet. I gave her the High Court transcript.
yeah.
I gave her the High Court transcript. I said, listen, this is what the High Court judge said, and this is binding on you now.
Yeah, I remember there. I'm sure you raised this a case. I can't think. It was a Victorian case where the guy was unrepresented.
Yeah.
And the judge bent over backwards. And it went for months because he was, he really didn't have a clue.
Slabesky. Yeah, so the guy had Tourette syndrome, and during the hearing, he was like, why don't I fucking kill your family? Or blah, blah, blah. And then he wrote an email and he said, would you start making better orders if I paid you $5,000? Like, you know, it's just,
Yeah, but the judge bent over backwards too.
it was Keo.
Yeah.
Yeah. And
was not Kyo.
it wasn't Keo? Who was it?
I don't remember the name.
Kairu. It was Kairu or Keo, one of those. Kairu,
Right.
yeah. But, good senior. I think Kairu is in Court of Appeal now.
Yeah, I think you're right.
Yeah. So, but that is a leading authority. Slabesky, everybody knows about it. But also, Justice Bell, he's done some very, very good cases. There's Matsuka Tiru, and which, by the way, Victorian Bar uses for its own fucking promotion about, how they help people. It was all so. Basically, their house was burned down by arsons, and then the city or the government agency that's responsible for making sure that structures are secure kept sending them notices, which were sent to the burnt house where they weren't living anymore.
Right.
And then basically they were convicted of a criminal offense at the magistrate's court because it was a criminal offense not to do this or that. So they came to the magistrate's court, and I think they couldn't attend because it was mother and daughter, and they maybe got sick, and they couldn't attend. And then they raised an appeal at the county court, and something very similar happened. And then basically they raised a judicial review of it and went to Justice Bell. And he wrote such a fucking long judgment about, the injustice of it. And Victoria Barr represented them pro bono.
Yeah.
So I'll send you a video. Victoria Barr has produced it about how serious injustice was prevented because of their thing. But
Yeah.
uh, that's that's one, and there's another one where that the same judge has done about self-represented litigants, where basically a school teacher who had a problem with the police, and the police kept going after him for nothing. So he became very, you know, um, he was very motivated to go after the police, and he brought some proceedings and so on, and basically it didn't go his way because it wasn't so much that his legal the law that he was relying on was not right, but it was presentation related or something. And then he wrote a very long article, and he cited all the treaties and all the government articles that are relevant to self-represented litigants. And he said basically, the courts need to be empathetic, and they need to understand the human element. And by the way, that's in the judicial training material. Um,
Games
but
of driving.
it was
Oh,
it was so I think Peter, we just need to be proactive, and if we finish the stuff, which we have enough time, to be honest, I think this is the best outcome that we could have gotten in the circumstances, because one, the matter is delayed.
Yes.
Two, they've accepted the listing of the contempt application.
Yep.
Now we will publicize everywhere that we've lodged a contempt application against them with their consent
Yes.
for perversion of the course of justice by starting that bullshit proceeding and doing this thing. Now she hasn't left enough time for the contempt hearing, and we will turn it on her head because we will say we need to call witnesses. It's a criminal fucking charge. If she doesn't let us call witnesses, then so we call tens of witnesses who will say the nastiest things about. I mean, Thomas, the first thing he will talk about is how, Joanne Jenkins was telling him about what the going rate she charges is and blah, 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 blah. I mean,
is Thomas going to come?
on the last day, when after the affidavit was done, he was like, I want to make a quick amendment. I want to write there that she told me that she was sleeping with people at the LSB to get a job. I mean, do you understand what I'm saying? Like, he wrote to me, there's a text message there, which I will put into evidence and ask him about. So, like, he will give all of that evidence. And I will ask him why he didn't go to IBAC or any of the government agencies. I mean, basically, what this is, as I joke, the Godfather movie. All this while, I was trying to prove that once I stand up against them and start breaking them, everybody will come out of the woodworks. That's what happened. And the irony is, that's what happened despite Gorton standing and saying that we're wrong. You know? Like, people can see what is right and wrong. So once we start publicizing and getting back to people, I mean, we'll put it in the thing that there's a practical legal training institute in New South Wales that was asking if you want to,
Yeah.
teach
Lecture of
people
them.
on
Yeah.
legal ethics.
Yes.
Like over the weekend, we need to um, do an affidavit as well about your issues.
Yes.
Um, like really, I'm gonna find recordings where we've discussed the
Yeah.
material.
I'm pretty sure I got a draft of something like that already.
I know, but I want you to be a little bit more punchy and exhaustive, and like make comparisons with what's happening with Joanne Jenkins and with the other thing. Like what you have to point out is that they did this, and they did it because of this reason and that, because you were not reaching client legal privilege. And you have to go into details about Gordon Cooper and how they tried to get the files from you, and all for fucking nothing because no one was charged with anything. I mean, these assholes, what you have to say is that, you've spoken with so many people now and you know that this is what they do to everybody. And
Yeah, no,
no,
absolutely. No issue with that.
and here's the other thing. With almost everybody, they managed to find some fucking way of charging them with some bullshit thing. In your case, they couldn't even find something to charge you with. Like, they couldn't even fucking charge you with discourtesy. Do you understand? Like, like there's so many ways in which they can screw with people by charging them. And nothing. The only time that you were in court, besides the fucking bullshit contempt matter, was when you started a proceeding and they were trying to cheat you. So
Yes.
here's the thing: like, if you're such a bad person, why are you still on the fucking roll? Like, why do they have to get a fucking injunction where it's clear why they have to get an injunction, because Gorton did it without fucking any evidence. But you don't get an injunction against. So you don't get an injunction against a lawyer who's on the roll to stop him from doing what he can do when he's on the roll. It's such a stupid fucking thing. Like, there's no basis for it. And like, this one, what's her name? Downs. She herself said in the injunction judgment, that the court will not give an injunction unless it is absolutely necessary and there's no other way. And also, the people against whom the injunction is being issued, they have demonstrated a capacity to continue to do something repetitively, and the wrong thing. Here's the thing: Gorton already found that you thought that you had the right and you hadn't done anything wrong.
Yeah.
And he's already in the other matter determined that, yeah, horrible stuff happened, and if it may have happened horribly, and there's a public interest and all that bullshit. Yeah. After I
Mm-hmm.
called him a scoundrel. So then, that is so fucking stupid, because on one hand he says that there's a public interest that the LSB should be put to account, but he has judicial immunity. Do you know what I'm saying? One hand he
Yeah,
says that what was said about Mr. Ansel is that he's incompetent and dishonest and blah blah blah, like his words. And then he says if this was done for an improper purpose, then there's a public interest and he has a private right. What about Gorton? He blindly fucking accepted that. And I mean, all this while when he was like, well, if I made a mistake, even on the 26th of August, when I told him that he's basically breaking the law, and you know, then I called him a scoundrel and all of that. In that judgment, he says, well, if I've made a mistake, the appeal court will correct me. The problem is he hadn't made a mistake yet.
yeah, right.
Why didn't he start fucking reading the authorities? Like the 1st of November, when he said, when he said that it doesn't make any sense that a lawyer should be like, who's not on the register should be able to do this and that. There was not a single authority that he cited. Not a fucking single one.
Yep.
So the whole thing is just completely bullshit, and the everybody will see that. And I mean, Downs will see things differently once they're published. And the final thing is that the injunction, the wrong thing about it was that if there was no reason to believe that if the court ruled that you were wrong and they were right, then you would have continued to do this. What was happening is you were saying that the court should decide this, and until the court doesn't decide, I'm not going to accept your word, which is totally your right. And then they basically said, we're going to go after him with an injunction because the court should not decide this first. We should have the final word. And Gorton said yes. Do you know what I'm saying?
Yeah, yeah.
So we just put this out, and I'm sure. And here's the other thing, right? Once we file the contempt application, on Monday, there is no way she can actually. I mean, firstly, we will do everything else as well, which will then strengthen our position with the contempt application in the federal court. Like, if we file the appeal and all of that stuff, then it strengthens our position in the federal court.
Yep.
Contempt thing. But in any event, she cannot force us to wrap up the application in half a day. By the way, Lulu just pointed out that she never checked with us what our availability was.
And to us, no, we've never asked.
Oh, because they wrote the thing in the evening, and this morning she basically. So the availability, I mean, there's going to be a number of issues with the thing, and Lulu obviously is not available. So there will be a number of issues that she'll face, and then once with we start issuing the subpoena, she can't just once we file the subpoena, there's nothing that she can do. She has to. It will be listed, and by the way, in her email, though she did not say she will list the recusal application, she didn't say no either. She's not very confident about her position, and she's not sure. Like, she's not saying that she's not going to hear the thing or any of that bullshit. So I'm sure once I publish the stuff about Gordon and the process that I'm developing, then it will, catch fire. People will start appreciating it. And the worst part of all of this is that it reveals how there is no fucking check and balance. It's like everybody covers for the other person.
No, it looks awful for them.
And
Well,
by the way, after we, I mean, it just gives us a new tale to tell that this is how they tried to obstruct us. And then when so the only reason why they did this is to avoid the injunction hearing urgently, yeah?
yeah,
So we will tell everybody about this in our publication that basically they agreed to list the contempt application. And this, because of the way they do things, they don't really understand what prejudices they invite. So Heath is not a party to the proceeding, as they pointed out. He's submitted to the jurisdiction because he himself said that it can be listed then, and he's a lawyer and a person who's being charged. So once that happens, by the way, he can't be the lawyer anymore.
okay, yeah, no, I think you've said that before, yeah.
Plus, he will have to be represented because he's facing a criminal charge. Do you know, like, how can he be a lawyer in the matter when he's also charged in the matter? So he'll have to get a lawyer. Coors will have to get a lawyer. I'm not sure who's going to act for them. So once we file the appeal, this is going to look so fucking bad for them. I'm sure that they'll just want to drop the matter and say it's because of the appeal that they're dropping it. Like the substantive matter.
Yeah. No, I understand your logic on that, yes.
I mean, they need to find 3 law firms to represent them in that matter. One for Heath, one for Coors, one for LSB. For the contempt matter. I think they thought that we wouldn't file the application. And the judge, I mean, there was no fucking reason why she would give that tight deadline. And basically, she's not even amending it, which is even better for us. Because the court rules say you have to file the application with 3 days' notice. That's what the standard is for everybody.
Yes.
She's discriminating against us.
Right, of course, yes. Yes.
That's another ground that she is. I mean, there is no benefit in filing the application on the 18th. She cannot say that she cannot even say that these people, they tried to. If she had actually listed the matters based on the representation that the thing was being filed, then it would have been a different thing. Then she would have said, "Oh, you've already got my orders based on the fact that the application was listed, so you must list it urgently." But that wasn't the case here. And the other thing is that based on what she said, that this is the last opportunity, that means she's basically said we can never raise any matter in this proceeding anymore. After the first fucking case management hearing,
Yep.
she comes across completely unreasonable. And once we start saying that this is, I mean, forget about everything else. The other angle is that Gordon is the son of a prime minister and very fucking influential. And, this is just part of his fucking network. There's all sorts of allegations that come out, and her actions invite them.
Yes. No, I understand that.
So, anyway, the point is that, Gordon is politically connected, and the whole thing is about her not wanting to issue the subpoena against a judge. That's what we say. I mean, that's what it is, clearly.
Yes.
She doesn't want to give the subpoena because she knows that it will destroy Gordon's career. It's as simple as that. I mean, forget about the empathizing with the barristers because she was a barrister. I mean, she's
Yeah.
empathizing with a judge because she's a judge, or not even empathizing. She's just not wanting to destroy Gordon's career. It's as simple as that. Like, everybody knows that. And listen, what's his name? There's a leading publication that's big here and in America, and the editor of the publication came out strongly against the High Court judgment. Yeah,
Yes.
about the judicial immunity, and he said, what this means is that people are not equal, and
Yeah.
we will write to him. We'll say that this is what's happening to Gordon. And in the judgment, what the court had said is that there are already checks and balances, because if people know that there's a corrupt judge, who's going to fucking put up with it? And the government will kick him out, and the Court of Appeal will, shred him to pieces and blah, blah, blah. And we give examples of what's happening here.
Yeah.
And with the bankruptcy court, and everybody's basically trying to protect him. And I'm sure people will write our story about what we did and how we. I mean, you don't need a court judgment to say that Gordon is corrupt anymore, is the whole point of it. Like, I was thinking about, what's the worst thing that can be said about Gordon that he's not already said about him?
There was not much. you haven't left many insults
Like,
out.
that day when I was like, it doesn't even matter whether you're taking a bribe. And then he was like, okay, so all these cases you refer to, do you want me to read them? And I'm like, you're missing the whole point. And he says, but do you want me to read the cases or not? Like, he's changing the subject. Like, do you know what I'm saying?
Yeah.
Okay, I'm gonna go now. Then, Peter, I mean, they have basically agreed to get charged with contempt. And, we'll also subpoena Stephen, the lawyer, and he'll have to tell the truth, whether the LSB contacted him or not. I mean,
Yes. Walters.
yeah.
Yes. Even Walters. Yeah.
Yeah, if you subpoena him, and because we have to subpoena him, that was the whole point of the thing, that they spoke with him. So if you subpoena him to give evidence, and by the way, the other point is that she ruled against us when Bennett had ruled in our favor. All these matters were before Bennett, and they said the applications are not before you. And I said, of course they are before you. They're right in front of you, and we can seek leave right now. And then I said, if you think that it makes any difference whether or not it was filed, then you hear us. And she said, yes, I will. And she didn't, because it then doesn't make any difference. So, and in the judgment, she said that we will have to be heard before the utility is decided. So none
Yeah.
of that was done by this one, and she didn't even fucking give any reasons. Like, she didn't give any reasons why she didn't issue the subpoena. She didn't give
Yep.
any reasons why she listed the matter without asking us our availability, or or why she's not letting us subpoena for the hearing. So we go in, we put the thing, and once we get Stephen Walters in to give evidence, they'll be fucked. Because
Oh, yeah.
the thing is, I know that on the tape you heard the recording of me and what's his name,
Flip.
Flittner, about what Walt. So he said Walters had like a 45 minute or an hour long interview with the Peter Kerr guy,
Yeah.
and he says what Walters told him was that there's not a single lawyer that Flittner hired who was then not investigated by the LSB. He's saying that in the recording. He says he was sitting next to me and he said that, and I was like, okay, but he can't fucking give evidence in court. He doesn't have the balls to do that. And then Flittner was like, well, what can I do? So we can subpoena that interview too, because we have the thing, and we'll ask Flittner, Walters, those questions. And the simple fact is this, Peter. The material that will come out against the LSB during the hearing will destroy them. Because with the Joanne Jenkins matter, what I will say
Yeah.
is that he was wronged, and anyone who heard his story would want to help him. And I mean, I'll call you, and we'll have the discussion about why we agreed to raise the matters and all the things we considered, and all of that will be published. So they don't survive this now, because what they've done is they've made it the central fucking issue. And the other thing is, we're not going to let them close the court. So I'm going to let you go.
Yeah.
Yeah. Okay. Cheers. Bye.